This is an interview with Thomas Saenz, the President and General Counsel of the Mexican-American Legal Defense and Educational Fund. Tom, it's wonderful to have the chance to welcome you here to Notre Dame and to the Institute for Latino Studies.
Thank you. Thank you. I'm grateful to be here.
Tom, why did you choose civil rights as the focus of your legal career?
Civil rights is why I wanted to become a lawyer. Although when I was growing up, I did not have any exposure to lawyers, or none in my family, none in my neighborhood. I, through reading of history, understood the prominent role that lawyers have played in policy setting for the nation, but also particularly in the struggle for civil rights. In particular, the efforts of the NAACP Legal Defense Fund leading up to and then achieving the really ground-setting decision in Brown versus Board of Education. But I concluded that if I had an interest in social change and public policy, that becoming a lawyer was a good way of securing a position in those areas.
Why the Mexican-American Legal Defense Education Fund? You went to Yale, graduated from Yale Law School, you clerked for a federal district judge and then for a judge on the Ninth Circuit. Did you go into the Mexican-American Legal Defense Education Fund right away? Did you spend some time elsewhere? And if you went in, I know you went in relatively soon, why that particular civil rights organization?
Well, MALDEF is the Latino civil rights legal organization for the Latino community. So as a lawyer wanting to serve my community, that would be the natural place to go, certainly then, and I believe even today. And I did join MALDEF right after the clerkships ended. I had done some work as a law student and working at a law firm in Los Angeles where the former President and General Counsel, Vilma Martinez, who is one of my, well, my #1 professional mentor throughout my career. She was a partner at the law firm. I worked there, and she arranged for me to do a pro bono assignment for MALDEF. So I got to know the then Vice President of Legal Programs at MALDEF through that assignment, and got to know the then President Antonio Hernandez a bit through that assignment. And I certainly was aware of MALDEF through my conversations with Vilma, but from my study of Chicano history. And that was always a dream job. And when the offer was made, I was immediately accepted. It's what I wanted to do.
Why did you choose Yale Law School? My guess is, given that you were at that time and still are a summa cum laude graduate of Yale, as an undergraduate, that you would have had opportunities to go to law school anywhere you wanted around the country. Yale's an excellent law school. Just wondered why you chose to stay there.
I chose to stay at Yale, though I took a year off between, so it wouldn't be 7 straight years. Because certainly at the time I believed Yale Law School to be the best law school, and a law school that emphasized more perhaps than others public interest, government service, though of course, like all law schools, most of my classmates went into the corporate sector early in their careers at least, but it was and is still known for also teaching. A high proportion of Yale law grads go into law school teaching. Thought I might have some interest in that, but it was really the expected greater influence, though still not what I would have hoped it would be, on public interest in government service. Yale Law School also has a more relaxed atmosphere in comparison to other law schools that can be much more, at least by reputation, cutthroat in competition.
What would you say are the 2 most important cases you have litigated? You were actually one of the lead attorneys in arguing so far over the course of your career. I assume there'll be many more. But what would you say are the 2 that mean the most to you as you look back at this point?
Well, simply because of the importance of the issue and its importance in my development as a civil rights lawyer, I would cite the federal case against Proposition 187
Can you explain Proposition 187 a
Sure.
little
Proposition
bit?
187 was a popular initiative passed by California voters in 1994 by 58% of the vote, though three-quarters of Latino voters voted against it, and majorities of African American and Asian American voters voted against it. It still passed because of the proportions of the voting population by 58%, and it was a omnibus restriction, attempted restriction on the rights of immigrants, though it would have impacted everyone, affected everyone, and would have required that every person accessing public services, from school through university, through social services, healthcare, to prove their status, their legal status, before receiving those services, with a cascading set of consequences if they could not prove their status and if they were reasonably suspected of being undocumented. It was, at the time, a national issue, and MALDEF was one of two leads in the most significant of several federal court challenges to the proposition. So I would say my participation and role, increasingly prominent role in that case as it progressed, is one of the two most important, and I have a tie for the second.
Okay, well, tell us about those two in the tie for second.
One would be the challenge to redistricting, particularly congressional redistricting in California in 2001, where MALDEF pursued the only challenge to redistricting that year, and it focused on two congressional districts that should have been majority Latino but were gerrymandered not to be.
Was that your first voting rights case?
No, but it was the first redistricting case. Just prior to that, I had played a role in a trial of a challenge to an at-large local election system in Santa Maria, California, where I was second chair at the trial. But I would say that's one of the two that's tied for second place, and the other would be a case that is really a series of cases, but ultimately very similar cases, but ultimately went to the Ninth Circuit, the en banc Ninth Circuit, which is when a court of appeals, a federal court of appeals, decides to rehear a decision by a three-judge panel. In this case, it's heard in Ninth Circuit by a panel of 11 judges, but a case against the city of Redondo Beach challenging their anti-day laborer ordinance, an ordinance that restricted the right to solicit work from the public sidewalk. It was one of several in a series of cases that MALDEF and I had been involved in, with a series of victories beginning with Los Angeles County, but Redondo Beach was the case that resulted in a Court of Appeals decision. We got 9 out of those 11 judges to rule with us and strike down the Redondo Beach ordinance. And I had started the case when I was at MALDEF and then left to work for Mayor Villaraigosa while the case went on. But by the time I returned to MALDEF as President and General Counsel, I was able to participate in a leading role in drafting the request that the case be reheard en banc by those 11 judges, and then I was able to argue the case before the 11 judges. So I would say that's the other case. So 3 cases, sorry.
So why were those 3 cases so important to you?
I think
understand, we have a sense of the issues, but why to you personally were these cases important?
For different reasons, but I think that they relate to my development as a lawyer, particularly with the Prop 187 case, and opportunities that increased over time, sometimes as a result of happenstance, and opportunities that are unexpected, and also just by my maturing as a civil rights lawyer. I think that the redistricting case, primarily because it was before 3 judges, as redistricting cases are heard before a 3-judge trial court, including the judge that I had clerked for previously, who ruled against me. But it was MALDEF and its clients against the whole state political apparatus,
The Democratic Party.
Democratic Party, the Republican Party, but particularly the Democratic Party and elected leadership in the state. So I think it was important in that regard, taking on difficult, politically controversial issues, as so many of these are. And then I think with Redondo Beach, it really is about tenacity. The first case I was assigned to as a young staff attorney at MALDEF was a state court challenge to an anti-day labor ordinance that had been filed previously and was then on appeal. And that appeal did not succeed, and I came in at the very tail end trying to have the appellate decision reversed, but then stuck with the issue and moved the venue to federal court, and all of the other groups that had been with MALDEF and the state court challenge were no longer interested in pursuing these cases. We did, and pursued a series of cases in federal court raising the First Amendment issue that ultimately culminated close to, I guess, a dozen or more years later, and more than 15 years later, in the Redondo Beach appellate decision. So it's tenacity in pursuing a meritorious claim over time, designed to reach the goal of a more broadly applicable precedent, as from a court of appeals, to then wipe out other ordinances without having to file litigation, which is what we've done. And at least a dozen, I believe, cities have, through our urging, abandoned, repealed their ordinances because of that decision.
You worked for, I believe it was 4 years, as counsel to Mayor Antonio Villaraigosa in Los Angeles. You hadn't done that type of work before, I don't think, been
That's right.
counsel to an elected official, an extremely important position in the country, second largest city in the country, very complicated community, growing, dynamic, tremendous amounts of wealth, tremendous amounts of ethnic, racial diversity, and every other type of diversity one might want to think about. What did you learn from those 4 years that made an impression on you that you think it's important for others of us to understand?
I learned a great deal, from the very mundane to the very consequential, but I have always said that there are 3 really enduring lessons that I learned from that experience working on his executive team. And one is that bureaucracy is as bad as we imagine it to be, and bureaucracies can be obstacles to achieving progressive social policy in multiple and varied ways, sometimes by intent and sometimes not. But there is a need to try to address how to secure progressive, significant, and enduring policy change with entrenched bureaucracies in major cities and obviously states and federal government. Second, I learned in part because of being specifically assigned to work with the mayor on his attempts to change the governance of the Los Angeles Unified School District. I learned that we do need to look at, with an open eye and a critical eye, and open to questioning long-standing structures of government and determine if they continue to serve our interests as a people in the 21st century. One example is the separation of school governance from the governance of all other significant local municipal services, which for historical reasons developed, historically appropriate reasons developed, but we need to openly ask whether that still serves us given changes in the community and government, whether separating one of the 2 most important municipal services should be apart from every other municipal service. We have to openly question that. And the other example is the separation of city and county government, where we have two different and parallel, with different responsibilities, local government agencies serving the population. When you're dealing with complicated issues that cut across different services, some assigned to cities, some assigned to counties, it's hard when you have a separation of those two governments to arrive at and successfully implement solutions. So I think we have to be open to questioning structures that we've inherited and that may have developed for very good reasons at the time, but we need to question whether they serve us today, as well as other possibilities. And third, we really need to address the revenue structure for local government and the ability to ensure that in times of recession or economic downturn, cities, which become even more important, are able to deliver critical services, and that's hamstrung in California and in other places by barriers to revenue measures that are necessary.
Would you ever go back and work in government? If you had the opportunity and it were appropriate to your skills and interests, obviously, right, you'd be qualified for many different types of positions. Would you think about that after your experience in Los Angeles?
Sure, and I have. But I am comfortable today being on the outside, but knowing something about the inside of government from that experience. But certainly it is important to have folks inside government doing good work and supporting those on the outside, and as long as there's a shared understanding of roles and a shared understanding of how there may be conflicts, but those do not undermine the ongoing and long-term shared vision, I would do it. And, as you know, I did consider going from the mayor's office to a position in the federal government, and when that didn't work out, I rejoined, had the great opportunity to rejoin MALDEF as its president and general counsel, but I was considering that then. And certainly since then, my name has come up for certain judicial positions in government. And I was interested in some of those possibilities. So yes, but I'm quite comfortable now in doing what I do.
What do you see as the primary parts of MALDEF's agenda over the next, let's say, 10 years? Areas of work, issues that you think are high priority and that are going to structure a lot of the work that MALDEF is going to pursue over the next 10 years?
Well, I think that education, and in particular a focus on eliminating the education gap that Latino students face in K through 12 public education by focusing on outcomes and challenging disparate outcomes is going to be a critical part of what we do from both a policy and a litigation perspective. Education has been ongoing throughout the 47 years of MALDEF's existence, an ongoing part of our work, and it still needs to be, but we will be focusing, I believe, ever more on equity of outcomes measured in different ways, multiple ways, from public schools. We are still grappling with the need and need to prioritize achieving immigration policies and practices nationwide that are fair and consistent with our national constitutional principles and consistent with the best needs of the country. And that means in particular addressing the many millions of folks who have been here contributing to the country's development but without legal status. But it also means continuing our work, like the challenges to the day labor ordinances, the anti-day labor ordinances, continuing our work at local and state level to secure policies that are respectful of the constitutional and civil rights of immigrants, regardless of their status. And we are currently and will grapple for the foreseeable future with as we have throughout our history with voting rights and securing structures and policies that facilitate voters' participation, that facilitate the ability of voters to select candidates of their choice, and eliminating policies, too many of them, in implementation today that seek to restrict and suppress the right to vote. And we will be working to challenge those as we have in the past. But I think those are three critical issues, but they're all consistent with MALDEF's nearly 50-year history of using the legal system and changing the legal system to address the critical needs of the Latino community and more broadly the nation, vindicating constitutional rights and principles, and, as I would put it, ensuring that the legal system adjusts its frameworks, adjusts its paradigms, adjusts its tests for success of claims in court to the modern population in which Latinos are such a prominent and growing part.
Are there any new areas of litigation and policy that MALDEF is thinking of exploring in the relatively near future?
Well, I think that we are going to be looking at issues related to what is in the headlines today, and that is around criminal justice, disparities, and police abuse and reform. Latinos, given their growth and prominence as a population, certainly have experienced and continue to experience some of the biased outcomes in the criminal justice system, some of the biased encounters with law enforcement, and I think that MALDEF is interested in determining if there's an appropriate role for us as a long-standing civil rights national organization in that set of issues.
Very good. Our civil rights framework, our civil rights system, to a substantial degree has been driven over the course of time by the tremendous discrimination that African Americans have experienced. Latinos, whether Mexican Americans, Puerto Ricans, more recent arrivals, immigrants certainly have, for those who have been here a while, have experienced long histories of discrimination as well, going back to the original expropriation of land for those who originally had land when the war between Mexico and the United States occurred, and immediately afterward. How do you think Latinos fit into the civil rights framework, and help us better understand how we might think of how Latino communities today fit into the larger civil rights frameworks in the United States?
Well, we're at a time when we are celebrating the 50th anniversary of so many civil rights milestones achieved in the 1960s in response to the African American civil rights movement. And I think that Latinos now, as the largest minority group in the country, as we look to the next 50 years of civil rights protections, we need to ensure that they are adjusted and refined to address concerns today, including the prominence of the Latino community, where our history of involvement in the legal system, going back to its very origins, with the first Latino discrimination, anti-Latino discrimination case to go to the U.S. Supreme Court in 1954, Hernandez versus Texas, the community's experience has been trying to adjust paradigms and tests developed primarily for the African American community and its experience in the South and nationwide to the Latino experience. So Hernandez versus Texas was really about taking a precedent that had existed for 18 years and used to attack jury exclusion of African Americans in the South, and trying to ensure that that same precedent would be applied to Mexican Americans in Texas, who had experienced the same jury exclusion over the entire course of history. But it began that way, and it has been continued struggle to ensure that the law developed for one experience with commonalities to the Latino experience. You've given examples of that, but it goes back to the Mendez case that predated Brown and challenged segregation in California public schools. But despite that history, trying to ensure that the experience of discrimination in the Latino community can be accommodated and addressed through these frameworks developed for the related but not entirely identical experience of African Americans. Particular examples of that is that the Latino community has faced throughout its history and still does, perhaps more than other communities, the phenomenon of discrimination by proxy, where it appears to be racially motivated discrimination but is undertaken in the name of discrimination on the basis of language or citizenship or immigration status or any one of any number of other characteristics that may be shared and held by many within the Latino community. So our experience has been fitting laws and doctrines developed for specifically racial discrimination to circumstances where there is a racial motivation, though not easily proven, and it is hidden behind some other basis for discrimination. I think that epitomizes that long-term struggle to have the community's experience fit within these legal frameworks, and developing new legal frameworks that are attentive to that and anticipate future potential discrimination mechanisms and bases is really where civil rights law, not just for the Latino community, but for the nation, needs to go in the future.
Since perhaps certainly the mid-1970s, I would say, maybe even 1980, some would say that there has been backtracking on many civil rights issues, that the traditional role of the Supreme Court, for example, that starting in the mid-1950s seemed to be more often than not perfectly, but more often than not, on the side, making majority decisions on the side of expanding civil rights protections for different groups. That starting in the mid-1970s and through the 1980s, the Supreme Court and many other federal courts have seemed to be much more questioning, harsh, and even reversing some decisions that had been made in the past. Do you see that trend changing over the course of the next 10, 15 years? Do you see that as a permanent shift in the way we come to understand aspects of the role of the courts in civil rights law?
I don't think that it's a permanent situation. I think that we still see even today the court is responsive, but also can take the lead on significant issues of social change. I think we've seen that with marriage equality, for example, where I think you would have to say the courts have played a significant role in conjunction with what's going on outside of the courts in changing significantly a civil rights policy nationwide. So I do, of course, agree that within the realm of race-based civil rights, since at least the 80s, there has been a retrenchment in the court system. I don't think that's permanent. I think the courts change. I think even individual justices change their thinking, in part in response to what's happening out in the community, and lots is happening out in the community for the growing Latino, through the growing Latino presence. I also think it's largely up to us whether it changes. How creative we can be about presenting issues, legal claims that target discrimination can play a major role in whether that situation is permanent. One of my other crusades, if you will, throughout my career is to have a broader view of what civil rights law is. Part of that's been forced on us. When we challenge anti-immigrant laws at state and local level, going back to at least Proposition 187, we do it through the Supremacy Clause. which is the part of the Constitution that says federal law is supreme over state and local laws that conflict. That 25 years ago, when I was in law school, would not have been viewed as a civil rights claim. Civil rights was about the Equal Protection Clause, due process clause in the 14th Amendment, the way the laws had developed from the mid-50s into the 70s, and maybe First Amendment cases, though that was really viewed as a civil liberties issue. But when we can use, I think one of the things that MALDEF has done, different constitutional provisions and claims, like the Supremacy Clause, to accomplish civil rights means. We've also used the First Amendment in the day labor cases, not in a civil liberties context. That's very much a civil rights context. We have used, or attempted to use, the Contracts Clause, which is a clause in the Constitution that says states can impair contracts to accomplish civil rights means. We used it in another case against Proposition 187 to challenge the provision related to university education, arguing that undocumented students had already begun a 4-year course of study, that Proposition 187 basically impaired their contract to continue that education. So Contracts Clause, for example. I'm, as I say and have said many times in public speeches at law schools, I am looking for a good Takings Clause case that accomplishes civil rights means. The Takings Clause is a clause that says government cannot take private property without adequate compensation, been used very aggressively by the right to defend property rights. But I, for example, would love to find a case where an immigrant business owner could argue that their business was rendered a nullity and effectively taken from them by some anti-immigrant provision. I think that MALDEF and I personally may have the distinction of being among the first to bring a civil rights directed 10th Amendment case. The 10th Amendment was traditionally viewed as an anti-civil rights amendment because it's the states' rights amendment. It's the amendment that preserves the right of the states vis-a-vis federal power. And we've pursued 10th Amendment cases and considered them in other contexts. So I think we have to have a broader and more creative view of the Constitution and other sources of law in how they can promote civil rights aims. And I think that has two impacts. Number one, it may cause the Supreme Court justices who seem intent on restricting civil rights, but at the same time intent on expanding the rights of businesses and other economic interests. It may cause them to be more cautious as they expand on the side of business interests and economic interests to understand that it's a double-edged sword. What they develop for them, we're going to use it for us on behalf of the people as well. But the second effect is it does mean that we can go to them with claims on behalf of civil rights where they will have to be considering applications outside of the civil rights context and how that might affect their views with respect to those other areas of law. So to the extent we're more creative in what we bring to the court, I think that can also play a role in reinvigorating the role that the federal court system can play in promoting civil rights aims.
You've been very active, in addition to all of the civil rights work that you have, in the legal profession. Participated on committees of the American Bar Association. Because of your role, you give many talks at law schools and talk to young law students. How has lawyering changed over the last 15 to 20 years? We read stories in the news about unemployed lawyers, unfulfilled lawyers, unhappy lawyers. Has that affected your specific work in the civil rights arena in the same way that it seems to be affecting other sectors of the practice of the law in the United States today?
Well, certainly, at least indirectly, it has affected our public interest sector as well. In some ways, it means that we have a broader pool of potential lawyers interested in doing this work. as some have had to change their ambitions from perhaps being involved in a different sector where the opportunities may have become more restricted. But also, I think that change has meant that there are certainly challenges from the resource perspective in the public interest sector, dictated by some of those changes in the broader legal economy that present challenges. But I would also say the changes have primarily been in the private sector. And that does mean, hopefully, we are arriving at a more balanced configuration of the legal community in this country. We have always, as many have pointed out, perhaps had a glut of lawyers serving the more moneyed and powerful interests in the country, and we have never had enough lawyers who are serving the poor, who are serving individuals, who are serving those who do not have money and authority. And hopefully we can arrive at a more nuanced understanding of the legal needs and legal profession and not conclude there's too many lawyers, when in fact that's never been the case for the sector serving the needy.
You've been involved, I'm sure, in hiring young lawyers in MALDEF and in other places. What do you look for as the key to someone who you think not only can make an immediate contribution to this work, but is likely to make this work part of her or his long-term practice of the law?
Well, you're looking for the fire in the belly, as they say, the commitment long-term to civil rights, to public interest law. And how do you identify that? Well, certainly we're looking for folks who have demonstrated a history of activism and involvement throughout their lives, including their lives in school. I learned much of my advocacy skill not in a classroom, but by being active in groups like MECHA, the Chicano Students Organization, as an undergraduate, and being involved on those issues in law school as well. So it presents opportunities to practice some of the advocacy that we now engage in professionally. So those experiences are important, not only in demonstrating the commitment, but in demonstrating an interest in developing some of the necessary skills to be a strong advocate. I think we are also looking for an intellectual interest in these issues, demonstrated in the kinds of coursework, the kinds of research and paper writing that students have engaged in. We are also certainly, I think, looking for a community connection, whether that's from an experience growing up, but maintaining those connections, or from developing those connections through work with communities, extracurricular activities and the like with the community. That I think all of those would contribute to a conclusion about whether there is that long-term interest and commitment to the work. And that's certainly first and foremost what I think we are looking for. But beyond that, we want people who have developed skill in writing, and clear, concise writing, and the ability to communicate plain language about complicated issues. I think we are looking for, and this is not always easy to ascertain, but people who are committed to litigation as a tool for social change. As I tell every one of our applicants, it's very easy to be seduced by the other elements of being a MALDEF lawyer. You get to go make community presentations, you get to go make speeches, you get to talk to the media, you get to go advocate before government bodies directly for policy change. They're all very important, but they're also very seductive in the sense that the folks we're getting who have been activists throughout their careers, educational careers, they've done lots of those things or things like them before, as I've described. What is unfamiliar is the courtroom work, the litigation work. So we're looking for those who have a deep commitment to litigation and will want to do whatever it takes to pursue litigation as a part of a broader strategy towards social change.
What do you find, I've seen you in the courtroom, I've read some of your briefs, you're an incredible litigator. What do you love about litigation? I'm making an assumption there that you do love being a litigator when you've had the opportunity to be directly involved in cases.
I do love being a litigator, and I think you have to in some ways love the adversarial system, love the fight, as it were, and I think you have to love the fight at an intellectual level, because the briefs and the arguments are largely at an intellectual level, though to be really committed and powerful, you have to have that community connection, that gut level connection to the issues as well, I think. So it's not just an intellectual battle, but you have to love the intellectual element of the fight. And I think you have to believe in the importance of the endeavor, win or lose, and want to go back even if you lose, and indeed maybe be inspired to want to go back even more when you lose. So I think it's those kinds of attributes that demonstrate the commitment to litigation.
What do you see as the most significant challenges to finding funding for civil rights litigation in the United States today? My guess is it's varied over time, and certainly it must only cost more and more to be able to pursue cases as they should be pursued, getting expert witnesses, finding the attorneys, finding partners in other organizations or pro bono attorneys and so forth. Now, all of that requires some degree of resources. What do you see as the major challenges facing civil rights litigation?
I think the major challenges include the fact that litigation is still viewed as a disfavored mechanism for social change by many, in part because they may not understand it, in part because they see it as expensive, in part because of the adversarial nature of the litigation as I've described. It makes some institutional funders and individuals uncomfortable. And they would much prefer a less confrontational, less adversarial means of pursuing social change. I think that for some, it is controversial because of the issues. And it's easier for many to invest their philanthropic dollar in a scholarship program or in a mentorship program. And these programs are very important, don't get me wrong, but that's a little less controversial than having to defend someone being a major donor to an organization that engages in litigation against government, litigation against private industry. It's something that's more easily defended for those who may be concerned about how their colleagues or even their supervisors might see their philanthropic giving. I think we also face a challenge that's separate, which is fee shifting, enabling plaintiffs who prevail in civil rights cases to collect attorney's fees from the other side is in danger, and something that we as a nation need to attend to. Today it manifests in two different ways. As we are more creative with these claims, sometimes the claims don't fall within the federal statutes that permit fee shifting. So it is an open question. That's whether when you pursue and succeed on those claims, whether you can call upon the fee shifting statutes that clearly apply to civil rights claims like equal protection and due process to these other claims. And the other danger is some civil rights litigation has to be in state court. And there are many states, California and Texas among them, that do have strong fee shifting. But there are other states, where there are important issues to litigate that don't have fee shifting under state law. So you may pursue a critically important education case because of a Supreme Court decision in 1973. In fact, its anniversary was just a few days ago. We are largely confined to state court and state law in waging challenges to education inequities. And there are many states where you pursue those very expensive cases, and even if you prevail, there's no fee shifting at the end of the day, which means there's no reinfusion of resources to support the next case from that victory. Mm-hmm. So I think we face a number of challenges. We need to more attentively seek strategies to address them.
What final word would you have to help guide recent college graduates, almost graduates, who are thinking about law school and maybe considering civil rights work? What words do you have for them, advice do you have for them that would help them think through whether this might be an appropriate option for them to consider?
Well, I think for anyone, whether they're considering law school or otherwise, I think they need to really understand their commitment to civil rights. It will be necessary to get through difficult times in law school in particular. But I think that all future leaders in civil rights and social change have to develop courage, develop tenacity. Even when you lose, you got to keep going. Develop an opportunistic devotion to challenges. Whatever challenges come your way, take them on with vigor, take them on with your whole self. Whether they fall within your current notions of what civil rights work may be or may not be, take those challenges when they come. And I think really develop your internal strength and commitment from family connections, community connections, social networking connections, the gut that is going to be with you and protect you and promote the interests that you are serving, and recognize that you are not alone, that you are doing that with the history of so many who have come long before me, and with an ongoing community of folks that are in support of what you are doing when you speak up for the community, when you speak up for the powerless, which can be daunting, but develop that strong sense of self that is essential to successfully taking on those challenges.
Thank you, Tom Saenz, President and General Counsel of MALDEF, for speaking with us this morning.
Thank you.